Hello everyone. Welcome to KPS की Kanooni Kaksha. I am Shyaam Chakrabarti, Senior Associate with KPS Advocates. Today, the topic for our Kaksha is Section 5 of the Arbitration and Conciliation Act. Section 5 talks about the extent of judicial intervention in a process of arbitration. The presentation will be given by Ms. Chakshu Huda, who is an aspiring lawyer, and the concluding remarks by Advocate Kaur Pal Singh, Founder and Managing Advocate at KPS Advocates. Without further ado, let the Kaksha begin.
This presentation focuses on Section 5 of the Arbitration and Conciliation Act, which deals with judicial intervention. Moving ahead, first we need to understand what is arbitration. Arbitration is a procedure in which a dispute is submitted by agreement of parties to one or more arbitrators who make a binding decision on the dispute. In choosing arbitration, the parties opt for a private dispute resolution procedure instead of going to the court. Now, there are certain basic principles of arbitration that need to be kept in mind. The first being, arbitration is consensual, which means that all the parties that are included in the arbitration procedure shall have consented to the same. The second being, the parties choose the arbitrator or arbitrators, which means that there can be more than one arbitrator, and the parties have a free right to choose the arbitrator that they wish to. The third being, arbitration is neutral, which means that there shall exist no bias on either party. The fourth being, arbitration is a confidential procedure and shall not exceed the limits of the parties that are included in the procedure of arbitration. And the fifth being, the decision of the arbitral tribunal is final and easy to enforce. This also escapes the lengthy procedure of the courts, which also includes red tapeism. Now we move ahead to Section 5 of the Arbitration Act, which explains the extent of judicial intervention. It states that notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. Now we move ahead to actually understanding the objective and intent of Section 5. One of the intrinsic objectives behind the enactment of Arbitration and Conciliation Act 1996 was reducing the scope of judicial intervention. Arbitration as a procedure in its whole aims to reduce the scope of judicial intervention and the lengthy procedure of the courts by opting for a private dispute resolution procedure. The Indian legislature, in conformity with Article 5 of the UNCIT RAL, Model Law on International Commercial Arbitration 1985, enacted Section 5 of the Act, which eliminates the scope of judicial intervention and enumerates that no judicial authority shall intervene except where so provided by the Act. Moving ahead with certain case laws. Now, moving ahead with the first case law, which is a case of 2006 named McDermott International versus the Bern Standard Company. Supreme Court in this case stated that the 1996 Act makes provisions for the supervisory role of courts for the review of the arbitral award only to ensure fairness. So the courts can actually intervene in the procedure of arbitration only to ensure the fairness in the procedure and not actually interfere within the arbitration procedure as a whole. The court further observed that intervention of the court is envisaged in few circumstances only, like in cases of fraud or bias by the arbitrators, violation of natural justice, etc. The court cannot correct errors of the arbitrators. It can only quash the award, leaving the parties free to begin the arbitration again if it is desired. Moving ahead with the second case law, which is again a very recent judgment of the year 2020 named Salarjung Museum versus Design Team Consultants. So here, the court held that where the jurisdictional objection is capable of waiver by the affected party, the failure to raise it before the arbitrator signifies consent to the arbitrator's jurisdiction. It was held that a party, after participating in the proceedings without any objection, cannot then challenge the validity of the proceedings under Section 34 of the Act and Section 5 of the Act. So here, if the arbitration proceedings are capable of waiver in the very initial stage, they cannot actually be questioned later on. Now, Section 34 of the Act also lays down certain conditions which go in consonance with Section 5 of the Act, which have to do with the dealing of the judiciary in the arbitration procedure. Moving ahead to the third case law, which is again a very recent case law of the year 2020, named Patel Engineering versus Northeastern Electric Power. The Supreme Court upheld that an arbitral award can be set aside under Section 34 if it is patently illegal or perverse. The court observed that the ground of patent illegality is available for setting aside a domestic award if the decision of the arbitrator is found to be perverse or so irrational that no reasonable person would have arrived at the same, or the construction of the contract is such that no fair or reasonable person would take, or that the view of the arbitrator is not even a possible view. So here, again, the Supreme Court laid down various conditions in which the judiciary can actually intervene in the procedure of arbitration. I hope that I have been successful in putting my point across. Thank you.
Hello everyone. Thank you, Chakshu, for explaining the law. Coming on to the topic, the intent of the Arbitration Act is to provide a flexible and modern method with an informal environment to parties. It also intends to reduce the burden of the court. Too much of judicial intervention will dilute the purpose of the Act, and hence, as Section 5 of the Act clearly states that no judicial authority shall intervene except where so provided, which clarifies the legislative intent and the main objective of the Act, that is to provide an alternative mechanism with the minimized role of the court in the process of settlement of dispute through arbitral tribunal. Even one of the objects of the Act specifically provides to minimize the supervisory role of the court in the arbitral process. It is noticed that despite the power with the arbitral tribunal under Section 16 of the Act, on certain matters, courts have interfered time and again, leading to passing of divergent findings on the appointment of arbitrator, power of the courts to intervene, and the subject matter of arbitration. New amendments were brought in to eradicate these difficulties. Post passage of award, even under 34 of the Act, there was a lot of judicial interference and awards being solely challenged with the intent to obtain an automatic stay, which has now changed. The grounds for challenge are more clearly specified. The concept of public policy has also been evolved, starting from the judgment of Renu Sagar, Sopai, Fulchand, followed by amendments of 2015 and 2019. Further, under Section 11 of the Act, where the parties have failed to come to the consensus on appointment of arbitrator, as per the agreement, and have finally approached before the court, the disposal of these applications has consumed huge time, delaying the initiation of the process and hence defeating the purpose of the Act. By 2015 amendment, the Act geared towards facilitating the speedy disposal of Section 11 applications by limiting the challenges to the decision made by the appointing authority and requiring the expeditious disposal of Section 11 within a prescribed time limit of 60 days. Further, based on the recommendation of the Law Commission report, to reduce the judicial intervention while appointing an arbitrator and to reinforce the competence principle enshrined under Section 16 of the Act, subsection 6A was inserted under the 2015 amendment, which state that the court, while deciding the application, shall confine to the examination of the existence of arbitration agreement only. However, due to divergent views on the above, the 2019 amendment in section 11 brought further insertion and structural changes to drastically change the procedure and nature of appointment of arbitrators. The new amendment introduced arbitral institutions for appointment of arbitrator instead of appointment through courts. The timeline for disposal of appointment application has been reduced to 30 days from 60 days from the date of service of summons. The main aim of 2019 amendment is to promote institutional arbitration in India by strengthening the Indian arbitral institutions. With omission of subsection 6A, the power of the court to examine the existence of an arbitration agreement has been taken away. To conclude, the law evolved has necessitated various amendments. The amendments are brought in to remove irregularities and limit the judicial intervention in initiating the arbitral process. The legislature has aimed to streamline the process of arbitration by minimizing judicial intervention into the same, as intervention beyond the four walls of the Act will certainly defeat the purpose of the Act. This being the intrinsic objective behind the enactment of Arbitration Conciliation Act 1996, the 2015 amendments has been brought, which has been further fortified, broadened, and deepened by 2019 amendments, which seek to restrict the judicial interference and broaden the scope of arbitral institution. Thank you.